They, I seek your lordship indulgence. My lord, in respect of item number 8, hearing, my lord. In this case, my lord, this morning I have filed one IA for seeking for striking out some of the names of the petitioners in the present writ petition. In fact, 7 of them have resigned from service and they would like to delete their names in the said writ petition. So if this case may be adjourned for a week.
You filed the affidavit, isn't it?
IA, my lord, IA.
IA for what?
For deleting 7 names of the petitioners from the writ petition.
No, can it not be taken up for hearing? We can very well delete it at the time of hearing also.
I just filed the IA. 7 of them have now resigned, so that they would like to withdraw and delete their names from the writ petition.
We'll do one thing. We'll have it on Monday or Tuesday.
On Monday and Tuesday, my lord, I have some other fixed items. If it is, your lordship can accommodate on Thursday.
Thursday is holiday.
Thursday is a holiday. We'll have it on Monday. We'll see what can be done.
Yes, my lord.
Mr. Victor L. Ralte, learned counsel for the petitioners, submits that he has filed an interlocutory application for deletion of some of the petitioners and therefore prays that the matter be posted again after a week. Stop. Considering the submission made, let the matter be listed again on 28/10/2024.
I'm obliged.
Stop. Registry to verify and connect the IA along with this writ petition. Yes.
May I seek your lordship indulgence in mentioning item number 9 of hearing matter. My lord, my senior is on lag, so if the matter may be kindly listed after a week.
Okay, item 9 as paid for on behalf of Mr. A.R. Malhotra, learned counsel for the appellant and not objected to by the other side. List again after a week.
For motion, item number 1.
Yes.
May it please your lordship. And my lord, this writ appeal is filed against the illegal action of the respondent, the State Bank of India, as a branch, where by invoking Section 13 of SARFACI Act, ordering us that to vacate and to sell the mortgage property.
Which is the order? Impugn order?
Page number 132 and 133. And that's 32. Page number 132 and 133. And this one is the vacation order.
In Excerpt 32.
And-
Vacation notice.
Yes, my lord, this one is the vacation notice. Vacation notice. And under Chapter 33, page number 134 and 135 is the e-auction sale notice.
No, just stick to page 132 first, Annexure 32. What is this vacation of what?
Vacation of LSC. My lord, we mortgaged 3 LSC. 3 LSC and 1 LSC, the location is at Cholmun.
You have taken loan,
Loan, yes, my lord, it's a tram loan. We took a tram loan in the year 2011.
11.
And the bank sanctioned us 5.25 crores.
Okay.
And 5.25 crores, and out of that, and I was issued 150 lakhs. 150 lakhs in the month of January 30, 2012. And according to the sanction letter, the first installment should be paid to me, should be disbursed on December 2011. And the second installment should be on March 2012. And the third installment to be on June 2013. And fourth installment will be on September 2013. But the first installment was disbursed to me on 30 January 2012, amounting to rupees 150 lakhs only, out of 5.25 crores.
So,
And oncoming of the disbursement for the second installment, I was not given the second installment. There, about 2 years was gap. And after that, in the month of 2015, I was given another letter. In 2015, 5th May. No, 9th May. 9/5/2015.
please come to the synopsis. You see, you don't describe everything, each and everything. You should try to, this is a case for motion, isn't it?
Yes, my lord.
So you have to simplify your submission. You have taken loan from the SBI. How much is the loan? Come to your synopsis, page 1. 5.25 crores.
5.25 crores. And out of that, I was sanctioned altogether 492 lakhs. Altogether 492 lakhs.
What is that? 492.
Yes, in total.
Come to your synopsis. Serial number 1 to 4. The total is how much?
5.25 crores.
Okay, 5. Then how much were you sanctioned in total?
In total, 492.
492 only.
Yes, my lord.
So you've defaulted in repayment
Yes, my lord.
and they've given you this vacation notice to vacate the LSC, which you have mortgaged.
LSC Cholmun. Location Cholmun.
How many LSCs have you mortgaged?
3 LSC.
Where is the location?
One is Cholmun and the other 2 is at Electric Vang Aizol.
Where are the details? Where have you mentioned the details?
In the synopsis also, my lord, LSC number 1, Cholmun is LSC number 2710 of 1987,
This is Solomon.
Cholmun.
Okay.
And number 2, LSC number 2, LSC number Aizol 12 of 1970, Electric Vang. The owner is Raukunga Chungte, the petitioner number 1. And
How many petitions are there?
3 petitioner.
They are all related?
Yes, my lord. Petitioner number 1 is myself, and petitioner number 2 is my wife. And petitioner number 3 is my son.
Okay.
Both petitioner number 2 and 3 are the guarantors.
Husband, wife, and son.
This man.
3 petitioners. Loan amounting to 5.25 CR. Then you have been given only 492 lakhs. What was the loan for?
My lord, the loan was for construction of a 3-star hotel at Electric Van. 3-star hotel.
Okay.
And I already constructed it.
Okay. Then according to them, how much are you, how much have you defaulted?
All together, my lord, is about 779 lakhs. 59,000, 779 lakhs, 59,759.
With interest.
With interest, my lord.
This is how much you have to repay. This is the amount you have to repay.
Yes, my lord.
How much have you repaid?
I have already repaid 325 lakhs, 31,613.
Please repeat again. 325.
325, 325, 31613.
Repaid.
Yes, my lord.
So outstanding is how much? You should have made a chart.
Yes, my lord.
Isn't it?
My lord, this one. Four five four 28146.
Please repeat. 4.
454 28146.
Means 4 crore 54 lakhs.
Yes, my lord.
28,146. So page 132 is the vacation notice. Before this, there must have been some notice for default.
We didn't see, my lord, before this. If I'm not mistaken, this should be this is the first vacation notice.
No, before receiving the vacation notice, did they not issue a notice of default that this is the amount you are due to us, which you have not repaid?
Page number 1162120. Page number 1162120, Annex 25.
Yes, this is the notice. How many notice did you receive? This is dated 6/1/2020. Long time back, 4 years back. Then what is page 121?
This is the stress assets recovery, my lord, notice.
Would you like to prepare your case first before you make a submission? I don't think you're ready today.
My lord, may I please have one submission regarding this one, the DM, the way how they carry on the vacation and the auction.
No,
It is-
tell me one thing. This is under the SURFACE Act.
Yes,
what,
my
what
lord.
is the remedy available to you?
My lord, here under section 14 of the Surface Act, the respondent have to follow strictly Section 14. They have to file application to the for possession to the DM, district magistrate, along with affidavit. They did not file affidavit also for taking possession. Before having a public auction,
No.
there should be a possession, my lord.
They ought to have done this, they ought to have done that. This is another thing. What I'm asking you is that in such kind of eventuality where you have been served with this vacation notice, what is the remedy available to you apart from 226? Under the SARFAESI Act, is there no remedy?
Now, my lord, the bank, the respondent, they file original application, NIA, in the Debt Recovery Tribunal, and the case is still been going on. And it is not disposed at this stage.
So you pursue your matter, your case there.
Yes, my lord, we pursue it there.
Before
But
the Debt Recovery
since
Tribunal.
Next 29, they try to auction our property.
So you apply before the Debt Recovery Tribunal that there should be no auction before disposal unless this application before you is disposed of. Why have you come before this court? Power of this court under 226 is very wide, no doubt. But when there's a remedy available under the statute, you are to go for that remedy. There are many judgments, especially pertaining to SARFAESI Act. That's why you see, you have not mentioned in your writ petition anywhere that you have exhausted all the alternative remedy available to you under law. And the remedy sought for is just and proper. That particular statement is missing here, which means that you are aware there's a remedy also available. You have not gone for that. So look into that aspect and come back to the court. What do you want to do? As paid for by Mr.
PC Dalthamwa.
P.C. Lalthangmoya, learned counsel for the petitioners. List the matter again. When? Monday? Next week?
Monday, my lord.
On Monday.
Obliged.
For orders, item number 4.
May I please your lordship?
Yes.
The petitioner is on interim bail, your lordship, and the petitioner went to the police station to furnish the bail bond. He was informed by the police that the case was charge sheeted and direct him to appear before the magistrate. As such, your lordship, the petitioner on 18/10/2024 appeared before the chief judicial magistrate. Your lordship, the petitioner is ready to face the trial. Kindly the interim order may be absolute.
Yes, PP.
Yes, my lord. As per the last court order, it is directed that the petitioner shall furnish a notice to Mr. Sizoram Chanalarnet, Special Public Prosecutor, and
Yes, I have furnished that.
okay.
I have furnished the notice to Special public prosecutor on 16/10/2024, Your Lordship.
Okay. Charge sheet has been filed already in the meantime.
Yes, sir. Yes, Your Lordship. And I'm appear before the magistrate on 18/10/2024.
What was the order passed?
Order on that day, order passed for the case is fixed today. Consideration of charge.
Matters fixed today for consideration of charge.
Yes.
Okay. Before the special court?
Before the special judicial magistrate court.
Which court?
Judicial magistrate.
Judicial
Chief
magistrate.
judicial magistrate.
Chief judicial magistrate.
Yes, sir.
See, if the charge sheet is filed already, today's fixed for charge consideration, why don't you pray for the bail on that before that court?
Because I'm praying for absolute my interim order. Your
I know. Now, since charge sheet has already been filed, and today's fixed for charge consideration, you pray for bail before that same court, before whom the matter is listed today.
No, Your Lordship, there is no such a fact that after finding the charge sheet, anticipatory bail cannot be allowed, Your Lordship. Because under section 482 of BNSS or under any other law, there is no provision of limitation for anticipatory bail, Your Lordship.
There is no provision for limitation, no doubt, but since the court is seized with the matter now, during the investigation, we normally grant the anticipatory bail. But once the charge sheet is filed, parties are directed to appear for charge consideration. You should carry forward your application for bail before that court while consideration of charge. Where is Mr. Zoram Sana? He's not a party to he's not appearing today?
No idea about it, my lord.
What do you say, Ms. Vanesyami? We had granted ad interim protection of
Yes, my lord.
anticipatory bail.
In the previous court date, it is instructed that the learned special public prosecutor has to produce the case diary. And now at the time, we didn't have the case diary, and I have nothing to say, my lord.
No, I'm asking you about the procedure. You're not appearing in this case, are you?
In the last court date, my lord, I didn't appear in this case.
No. This matter relates to economic offense police station case.
Yes, my lord.
So under the NI Act
Yes, my lord.
and also under the NI Act. So this is to be handled by Mr. Zoram Sana, I think,
I guess, my lord. He is the special public prosecutor.
for the
NIA.
NIA.
Yes.
So notice was served to him. He has acknowledged it,
Yes, my lord.
but he's not appearing today. Although you're not in the case, I'm asking you, in such a case wherein an interim bail protection is granted, anticipatory bail, and it so happened in the meantime charge sheet has been filed, what would be the procedure now?
Yes, my lord, in my opinion, it will be much better if they proceed the trial court for bail, normal bail, if it's going to be a charge consideration. Also, they can pray for discharge of the accused at that time in
Correct.
the charge consideration.
Discharge, and if not, at the same time for enlargement on bail.
Yes, my lord.
But Your Lordship, the court may grant anticipatory bail absolute because I rely on some judgment, Your Lordship.
Yes, what do you rely upon? Let's see. How many judgments you are relying upon?
3 cases, Your Lordship. I first take the reference of the larger bench judgment of High Court of Uttarakhand at Nainital. Kindly came to the page where I stick note. The bookmark. May I read the judgment, Your Lordship? Noted, stick noted. The page number is not properly here. Therefore, I stick noted the pages on copy, Your Lordship.
Page number is there on top of the page.
The page number is stick noted, Your Lordship. May I read the judgment portion?
Yes.
Judgment. I have perused the opinion prepared by my brother Manoj Kumar Tiwari J and Ravinder Maithani J. I agreed with the view taken by Manoj Kumar Tiwari J that an application seeking anticipatory bail would be maintainable even after the filing of charge sheet in the court. I may briefly record my reason for agreeing with the opinion of Major of Manoj Kumar Tiwari J. Right of life and personal liberty is a valuable right available to a person guaranteed under Article 21 of the Constitution of India, and it is one of the most precious and cherished right. The said right to life and personal liberty cannot be curtailed or deprived except without following the due process of law. Section 438 of the Code of Criminal Procedure, which deals with what is popularly known as anticipatory bail, seeks to prevent the apprehended infraction of the right to life and personal liberty of a person by providing that where any person has reason to believe that he may be arrested on accusation of having committed non-bailable offense, he may apply to the High Court or to the Court of Session for a direction under the said provision, and the court may, if it thinks fit, direct that in the event of such an arrest, he shall be released on bail. In Gurbakh Singh Sibba and others versus State of Punjab, the Supreme Court considered the issue whether the operation of an order passed under Section 438 of the Court should be limited in point of time, while recognizing the power of the court to limit the operation of such an order to a shorter period for reason to be recorded. The Supreme Court observed that the normal rule should be not to limit the operation of order related to the period of time. In Susila Agarwal and other versus State, NCT of Delhi and another, the same view has been taken by Supreme Court as noticed by both my learned brothers. Brother Maithani J has also noticed several judgments of Supreme Court in his opinion, wherein the Supreme Court considered the anticipatory bail application moved despite the charge sheet having been filed. These cases are following: Bharat Chaudhary versus State of Bihar, Ravinder Saxena versus State of Rajasthan, Binod Kumar Sharma versus State of Uttar Pradesh, Bhandres Bipin Bhai said State of Gujarat.
Madam, you please produce the Supreme Court judgment.
Yes.
Where is the Supreme Court judgment? The High Court, other High Court judgments are not binding.
I have a Supreme Court judgment.
See, other High Court judgments are not binding upon this court. It may have persuasive value,
Yes,
but it's
I
not
have
binding.
a Supreme Court judgment. Your Lordship, MD Asfaq Alam versus, yes, I have already.
Where?
All the copies are there.
You point out where is the which page?
Not in this copy. There are several copies. Yes, sir. Muhammad Asfaq Alam versus the State of Jharkhand.
Yes, relevant portion.
Relevant portion. Second, is that the Apex Court analyzed the judgment of Susila Agarwal versus State of. It is in page number 3 of para 10. Can my lord come to the page number 4? Already I highlighted there. The last portion of the para 7.6. While granting pre-arrest bail order, including limiting the operation of the order,
Just a minute. From where are you reading? From which paragraph are you reading? Or
I am
which
reading
judgment?
para 10, analysis, para 10, in page number 3. 7.6 is the clause.
You want to read from paragraph 10?
Yes.
Read.
Paragraph 10, not whole portion, your lordship. 7.6. It is in the page number 4 of the last para. 7.6.
7.6
Yes.
is in page 3.
Page 3. It is continued to page number 4.
You're reading the judgment of Mohammed Asfaq Alam.
Yes.
That's the one.
Yes.
So, which page? Page number 3 or 4?
It is started.
Page number 3 or 4?
Page number 4.
4.
4.
Page number 4, we have paragraph.
Paragraph. It is come from the 7.6, page number 3. It is continued to page number 4.
You just said page number 4. Again, you take back to page number 3.
No, your
Decide which page you want to show me. 3 or 4?
page number 4.
Yes, I'm in page number 4.
Yes.
What do you want to read?
Read the first paragraph.
Yes, first paragraph.
Matter conferred by the order, the applicant may in such case be directed to obtain an order of bail under section 437 or 438 of the code within the reasonable short period after the filing of affair. The constitutional bench has further observed that the same need not be followed as a invariable rule. It is further observed and held that normal rule should be not to limit to the operation of the order in relation to a period of time. We are of the opinion that the condition can be imposed by the court concerned while granting pre-arrest bail order, including limiting the operation of the order in relation to a period of time if the circumstances so warrant, more particularly the stage at which the anticipatory bail application is moved, namely whether the same in the stage before the FIR is filed or at the stage when FIR is filed and the investigation in the progress, or at the stage when the investigation is complete and the charge sheet is filed. However, as observed herein above, the normal rule should be not to limit the order in relation to the period of time. Again, the last para of the same page, 85.5, anticipatory bail granted can, depending on the conduct and behavior of the accused, continuing after filing the charge sheet till end of trial. The final portion of this case may read para 12 in page number 6. The final conclusion of the case is that in the present case, the court is of the opinion that there are no startling feature of element that stand out or any exceptional fact this entitling the appellant to the grant of anticipatory bail. What is important is not that the matrimonial relationship source almost before the couple could even settle down, but whether the allegation level against the appellant are true or partly true, this stage, this is at best would be matter of conjecture, at least for this court. However, what is a matter of record is that the time when the anticipatory bail was pending can be divided into two parts. Firstly, when there was no protection afforded to him through any interim order. Secondly, it was on so and so date that the High Court granted the order effectively directing the police not to arrest him during the pendency of his application under section 438 of the CRPC. Significantly, the investigation was completed and charge sheet was filed after so and so date, and in fact cognizance was taken on so and so date and by the session judge. These factors were of importance, and though the High Court has noticed the factor but interpreted them in an entirely different light. What appears from the record is that the appellant cooperated with the investigation both before so and so, when no protection was granted to him, and after so and so date, when he enjoyed protecting till the filing of charge sheet and cognizance thereof on so and so date. Now, I rely on this part. Thus, once the charge sheet was filed and there was no impediment, at least on the part of the accused, the court, having regard to the nature of the offense, the allegations, and the maximum sentence of the offense they were likely to carry, ought to have granted the bail as a matter of course. However, the court did not do so, but mechanically rejected and virtually to rub salt in the own directed the appellant to surrender and seek regular bail before the trial court. Therefore, in the opinion of this court, the High Court fell into error in adopting such a casual approach. The impugned order of rejecting the bail and directing the appellant to surrender and later seek bail, therefore cannot stand and is hereby set aside. This is.
Okay, what about the other case?
The other case, this one,
Kashinath Sukla,
yes.
what is the relevant portion? See, the judgment which you just read out just now, Muhammad Asfaq Alam, this was a matrimonial case, dowry case.
Yes, Your Lordship.
So the person was on interim bail all along. Ultimately,
But
charge sheet was filed,
The-
and the court said that you go and ask for a regular bail. Supreme Court said that under the circumstances, he ought to have been granted bail. So it'll depend on the facts of each case, isn't it? In your case, what are you accused of?
I am accused
420, 403, section
and
138,
of an act.
and what is the punishment? How many years?
How many years? The punishment of 420 for non-bailable offense is 7 years, Your Lordship.
427 years.
For
427 years.
7 years. And
And
other are the
403?
bailable offense, 2 years.
403, 2 years.
2 years.
And what about 138 NI Act?
Same, Lordship, 2 years.
2 years. Okay. Then the second case. Anything you want to point out? Kashi Nath Sukla's case.
Yes, Your Lordship. In this case, I am to read the para 18, Your Lordship.
Page 7.
It's page 7. Yes, Your Lordship. insofar as the submission of the learned counsel for the complainant that once charge sheet has been filed, the anticipatory bail of the petitioner should not be confirmed without considering the charge sheet is also devoid of merit. In support of the said connection, no provision of law has been shown, nor that is the mandate of Section 438 CRPC. In the view of the settled law, that filing of charge sheet does not affect granting of or continuance anticipatory bail. There does not appear to be any justification for the court to examine the entire charge sheet and the document annexed therewith for confirming the interim anticipatory bail granted earlier, especially when the petitioner has cooperated with the investigation throughout and did not misuse the liberty granted. Furthermore, when the charge sheet has been filed, the normal implication would be that there was no occasion for investigation agency or the police to require his custody. Para 19 also.
This is a judgment by the Delhi High Court.
Yes, Your Lordship. The same question arises here also. It is in para 4, Your Lordship. The prayer is, however, opposed by the learned counsel for the complainant. She submits that since the charge sheet has been filed and cognizance has been taken, the appropriate remedy for the petitioner is to withdraw the present application and seek regular bail before the learned trial court. And as such, the court decide in para 18, which I read earlier.
What is your good name?
Pinky Shield.
Cause list?
Item number 4, Your Lordship.
Okay, please write, heard Miss Pinky Shield, learned counsel for the applicant. You'll appear? No.
My lord, I
You'll not
have
be
no
appearing.
idea whether
So
I
you
will
take your seat.
appear or not.
None appears for the respondent, although a copy of the bail application has been furnished to the learned special public prosecutor under the NIA, Mizoram, Mr. C. Zoram Chana, on 16/10/2024. Next para. On 4/10/2024, court passed the following order. Please abstract that order. Next para. Today, Miss Pinky Shill, learned counsel, submits that pursuant to the order of this court dated 4/10/2024, the applicant has been asked by the investigating agency to report before the Chief Judicial Magistrate, since the charge sheet has already been filed. When?
The charge sheet has filed on 23/9/2023.
23/9.
This is the charge sheet now, Your Lordship.
Order was passed on 4/10. Charge sheet was filed before that.
This is not known to
It was-
the petitioner and not also me, Your Lordship.
Charge sheet was already filed on, what is the date?
23/9.
23/9/2024. Stop. The learned counsel submits that the applicant was not aware about the filing of the charge sheet by the investigating agency. Stop. She submits that the matter has been fixed today for consideration of charge before the Court of Chief Judicial Magistrate. Stop. She submits that since the applicant has been cooperating with the investigation throughout, the ad interim pre-arrest bail granted to him on 4/10/2024 may be made absolute. Stop. In support of hard submission, the learned counsel has relied upon the case of Muhammad Asfaq Alam versus the state of Jharkhand. No, you write like this: has relied upon the judgment dated. What is the date?
Asfaq Alam.
You print out these judgments all from Indian Kanun and all that and bring to the court. You should use the regular journals, or if not, neutral citations.
I'm using the Live Law and Indian Kanun app, Your Lordship, and I print out from there.
No, see, it's
It
more.
is a judgment dated.
It is more reliable if you go for the regular journals, not for just abstract from the website and all that. Judgment dated 31/7/2023 passed by the Supreme Court in Muhammad Asfaq Alam versus State of Jharkhand. And the judgment dated 15/2/2024 passed by the High Court of Delhi in Kashi Nath Shukla versus Government of NCT Delhi and another. In bail application number 1758/2022, criminal MA number 11512/2022, criminal MA number 2738/2023, criminal MA number 3893/2024, and criminal MA number 4629 of 2024. You will get this here in the heading, okay? And check out the number. Regarding that Supreme Court, you just enter this number also. Muhammad Asfaq Alam versus State of Jharkhand. Na? In criminal appeal numbers 2207 of 2023, arising out of SLP bracket criminal number 3433 of 2023. Stop. Next para. Since the learned special PP is not present, this court will have to consider the submission made by the learned counsel for the applicant and also the authorities that has been relied upon. Stop. The applicant apprehending his arrest in view of case being registered under section 420/403 IPC, as well as section 138 of the Negotiable Instruments Act, 1881, has applied for the instant anticipatory bail application. Stop. It is the case of the applicant that he has been summoned on several occasions by the investigating agency and he has duly cooperated, except for the last date, that is 22/8/2024, wherein he did not appear since he apprehended that he will be arrested. Full stop. Despite the non-appearance of the applicant, it is seen that the investigating agency did not arrest him. Full stop. now that the investigation is completed and the charge sheet has been filed, it only appears that the requirement of the applicant to be in custody may not be there. The apex court in Mohammed Asfaq Alam Supra, in the given facts of that case, observed that once charge sheet was filed, there was no impediment on the part of the court to grant bail. Having regard to the nature of offense, the allegations and the maximum sentence for the offense that were likely to carry you cancel that, likely to be invited. Accordingly, the order of the High Court refusing to grant anticipatory bail was set aside. And the appellant enlarged on bail, subject to the terms and conditions that may be imposed by the trial court. Full stop. Next para. Therefore, upon due consideration of the application and the materials available on record, this court is inclined to make the interim pre-arrest bail absolute. Stop. It is, however, made clear that the same is subject to the applicant being subject to the appearance of the applicant before the learned trial court, as and when he is required to do so. Stop. Failure to appear before the trial court without the permission of the trial court would entail cancellation of this bail. With the above observation and direction, the application stands disposed of. Right. You'll require the charge sheet copy. You take it back.
Item number 5.
If I may, my lord, this is jail appeal, and I have been appointed as the legal aid counsel for the appellant, my lord.
LCR is there? Your good name?
Dalram Dintharam, my lord. It has not been reflected in the cause list.
You're sure this is your case?
Yes, my lord. This is the appointment order.
Case number?
Case number is... The case number is not mentioned, my lord.
Then how you're appointed? For which, in which case?
This one, for the appellant, my lord. Ephraim Lal Nama.
Okay. Mr. Lalramdin Thara,
Yes, my lord.
learned counsel submits that he has been appointed as the amicus curiae by the registry in terms of the order of this court. Stop. It is seen that the LCR has been duly received. Stop. As such, comma, registry shall prepare the paper book expeditiously and list the matter for orders once a copy of the paper book is furnished to the learned counsels for the rival parties.
DB of like
What is the section involved here?
307.
307, okay.
Yes, ma'am.
Item number 6.
Lordship, I'm appearing on behalf of my senior, Mr. Bilaramenga. May I be given 3 weeks' time to file my written objection for the IA?
Objection. What is this IA for?
Condemnation of 226 days delay.
Okay. How many respondents?
1,
How much time you require? 2 weeks?
3 weeks.
3 weeks?
Yes, Lord.
No objection, my lord.
All right. Your good name?
H. Lero Sangi.
Miss H. Lal Rosangi, learned counsel appears for the applicant, while Miss
Lalmunmoy.
Lalmun Moy, learned counsel appears for the sole respondent, and prays that she may be granted further 3 weeks' time to file objection to the IA, seeking condemnation of delay of 2 to 6 days in filing the connected first appeal against order. Stop. Prayers allowed. List again after 3 weeks. Stop. Let objections be filed in the meantime.
For admission, item number 2.
My lord, we have received the additional affidavit in opposition, and pleadings are completed, so the matter can be listed for admission hearing.
Your good name?
Valal Thamwani.
Ms. Vanal Thamwani, learned counsel for the petitioner, submits that pleadings are complete and that the matter may be posted for admission hearing. Stop. Ms. Lal Rotfeli, learned counsel, appearing for the respondents, agrees to the said prayer. Stop. In view of above, list the matter for admission hearing after
2 weeks, my
2
lord.
weeks.
Item number 3.
Yes, my
Lordship,
lord.
3 weeks' time was granted to the respondents file their affidavit.
Yes, my lord, I'm representing the respondent number 1, 2, and 4. And if another 2 weeks' time may be given to file affidavit in opposition.
And 3, who's for 3?
Lordship, I'm appearing on behalf of respondent number 5. Similar prayer for respondent number 5.
Who's respondent number 3? Deputy Commissioner Kala.
Jonathan.
What are you seeking, Mr. Ramzao?
Lordship, the compensation R&R was assessed
At
under
just
the-
rupees
Land Acquisition Act of 2013, but that was not accepted. That was not accepted by the respondents. The respondents number 6, 7, and 8. 5, 6, 7, and 8.
What is this R&R awards? RAP?
This relief and rehabilitation under the
2013 Act.
2013 Act.
Okay, this
Yes.
is also another JICA.
Yes.
They want to apply JICA guidelines.
Yes,
There are
They
several cases pending.
they want that
Regarding
it should be
JICA
under the
guidelines.
JICA guidelines.
So let us have their response. We'll give them some more time. Mr. Sila Ramzao, learned senior counsel, appears for the petitioners, while Ms. Vanesiami, learned government advocate, appears for respondent numbers 1, 2, and 4, and prays for further 3 weeks' time to obtain instructions and to file counter affidavit. Stop. Ms.
Baby Laldin Zoli.
Baby Lal Dinzoli, learned counsel, appears for respondent number 5 and has a similar prayer. Stop. Now one appears for respondent number 3. Next para, the matter pertains to challenge made by the petitioners on the steps taken by the respondent authorities to adopt the JICA guidelines by ignoring the provisions of, what is that full form? 2013. By ignoring the provisions of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013. Stop. Having regard to the challenge made, further 3 weeks' time is granted to the respondents to file their response to the writ petition. List again after 3 weeks.
No.
For hearing, item number 10.
None appears for the appeal when the matter is called. For ends of justice, list the matter again after. No, for ends of justice, the matter stands adjourned for 2 weeks. Is that all?
Yeah, cái là